Fumi's career spans over 25 years, out of which she has spent over 16 years as a capital market operator and trust practitioner. She has distinguished herself in her area of core competence as a seasoned trust specialist, engaging in the structuring of complex legal, financial, and trust instruments, as evidenced in our participation in almost all the novel and groundbreaking debt capital market transactions in the last decade. Fumi is a past president of the Association of Corporate Trustees of Nigeria and a fellow of several finance and capital market related institutes and associations. What else can I add? Fumi Ekundayo is the MD CEO of STL Trustees Limited. Mr. Ekundayo, you're welcome. Please, can we have your opening remarks? Thank you.
Thank you so very much, Aki, for the introduction. That's much appreciated. My welcome remarks will be quite brief. Our very dear and distinguished participants, today, the 19th day of August, 2021, you are all warmly welcome to the webinar series, which is a third in the series of STL Trustees Limited. I want to believe that we're all keeping safe and doing our best to comply by all the safety and health precautions to protect ourselves from the Delta variant of the COVID-19. I also hope that as many of us as possible have been duly vaccinated to further protect ourselves. It is really a great honor and pleasure for me to welcome you to today's webinar. As I've been rightly introduced by my colleague at the beginning of the session, I am your host for this webinar, and I head the management team at STL Trustees Limited. Today, the theme we shall be exploring during our discourse and interaction is actually coined in the form of a question. So we're asking, how effective are corporate trustees and probate registries in the administration of estates in Nigeria? In our two previous webinars on the subject of estate planning, wealth preservation, and wealth transfer, we had examined and enlightened our audience on the evaluation of estate planning mechanisms in Nigeria, and also how to retain assets in the lineage using trust as a tool, respectively. Having examined these two prior topics, it became pertinent to address some identifiable challenges that could arise in the course of seeking to obtain probate and the role corporate trustees can play to assist you to surmount those challenges, thereby achieving your objectives in this regard. So essentially, a major objective of this webinar is to help our participants to be properly guided in the area of estate planning and wealth transfer. Also, the expected learning outcomes from the webinar would include the following. One, knowing what a probate is and under what circumstances you would require one. Knowing the process of lodging a will, knowing how to assess the assets left behind by deceased relations, including their pension benefits, the process of distributing a deceased person's estate amongst the beneficiaries and family members. Part of the learning outcome is also the knowledge of terminology of the documents required by the registries in processing probates. We will also be dissecting cost-efficient ways of processing probates, amongst others. We shall be considering two subtopics in the course of this webinar, with the first being the role of corporate trustees in the administration of estates, while the second subtopic is common challenges faced in processing probates and the panacea. We have two subject matter experts in the house who will be sharing their perspectives with us from a place of practice and also from a place of experience. The first sub-theme, role of corporate trustees in the administration of estates, will be handled by none other than Mr. Osaro Egobamien, Senior Advocate of Nigeria. Mr. Egobamien has many decades of law practice experience. He is one of the founding partners of Pechton and Grace, a full-service commercial law firm. Our second speaker is Mrs. Taiwo Akoni, and she will be making a presentation on the second sub-theme titled Common Challenges Faced in Processing Probate. Mrs. Akoni is the Chief Magistrate 1 at the Lagos State High Court, Ikeja Division, and HOD of the Probate Division. By the time our profile is read, you would agree with me that she's a square peg in a square hole for the purpose of treating this subtopic, as she'll be able to advise on how to surmount the challenges often encountered in the process of obtaining probates from the registries. The abridged profile of both speakers will be read and shared with you in a short while. By way of general information, we always strive to make our webinars participatory and interactive, and this one will not be any different. We therefore encourage you to kindly type your questions and inquiries and observations and comments in the Q&A box as the presentations progress. These questions will be duly attended to during the question and answer session. Please, you may feel free to anonymize your question if you so wish. That is, if you wish to remain anonymous when you want to push any question forward so that your name is not displayed. To do this, you can simply click on the appropriate button on your device. My colleague, Akioni, who is our head of trust services and legal at STL Trustees, will be our moderator for this webinar, and I will be yielding the floor over to him in a short while as he moderates the rest of the program. Once again, on behalf of STL Trustees Limited, I welcome you most warmly, even as we would like to thank you most sincerely for finding the time out of your busy schedules to join us for this webinar today. And the webinar promises to be quite insightful and beneficial to all participants. We are mindful of your time and the need to move on to other tasks that you might have for the day. Therefore, in our usual manner, we shall manage our time very well to enable us conclude within the 90 minutes we have scheduled for this webinar. We thank you very much. Aki, over to you, please.
Thank you very much, Mr. Kondayo. And like Mr. Kondayo has mentioned, we have 90 minutes, out of which we'll spend 10 minutes. So we have 80 minutes to go, and we'll do justice to the topics within the 80 minutes. Our first speaker, Mr. Osaro Egobamien, SAN, will be taking the first topic. But before then, let's try our preparedness for this session by trying the poll that will be posted in a moment. We want to see what your thought is on the usefulness of a corporate trustee. So the first poll says, would you rather appoint an individual or a corporate trustee as administrator of your estate? You have 60 seconds to do this, and the results will be announced thereafter. All the best. I think I have the result. For those who believe that, those who choose to appoint corporate trustees as their administrators, we have 72%. 8% will go with individuals, and 20% will appoint both corporate and individuals as their administrators. It is actually allowed for you to appoint both the corporate and individual. So going by this report, it shows that 92% will engage the services of a corporate trustees in the institution of their estate. So thank you very much. For the remaining 8%, we will see what you think after Mr. Goberman has delivered his paper, because we are going to pose this question again after the end of the first paper. Now I'll go ahead to introduce Mr. Osaro Goberman, who happens to be our first speaker today. And he will be speaking on the role of corporate trustees in administration of estates. As you can see on the screen, Osaro Goberman SAN is one of the founding partners of Pearstone and Gray's LP. Pearstone and Gray is a full-service commercial law firm with competence in power, energy and infrastructure, banking and finance, dispute resolution, capital markets, ICT law, and corporate and commercial law. He is actually the managing partner of the firm and leads its dispute resolution group with emphasis in crude disputes. He also leads the banking and finance group. Osaro was admitted to practice in England and Wales in 1989 and subsequently in Nigeria in 1991. He was conferred with the prestigious rank of Senior Advocate of Nigeria in 2008 in recognition of his diligence, passion, and contribution to the legal profession. Osaro SAN is the eldest son of late Sir Chief Dr. Alfred Ogogo Goberman SAN. So it's running in the lineage. They are both alumni of the Lincoln's Inn. Osaro also took an elective in law of trust at the Lincoln's Inn and has since been engaged in establishing cross-border trusts. At the same time, being proud of his heritage, he is assisting in creating simple estate plan for many of his father's clients. Osaro is currently the administrator of his late father's estate, who has seen the pros and cons of administration of estates. Hence, he will be talking to us not only from a legal and theoretical perspective, but also from his personal experience from acting as an administrator of his dad's estate, as well as his other practical experience from his law practice. Osaro is the Vice Chairman of the Convention on Business Integrity, trust and integrity being the cornerstone for the establishment of a living or testamentary trust. Osaro takes every available opportunity to teach law and legal practice, legal principle to young legal talents, and is regularly at the Nigerian Law School delivering lectures to the students. I think I should add that Mr. Goberman loves running marathon and is proud of it. And that keeps him looking younger every time you say it. Mr. Osaro, we are ready for you. The audience cannot wait to hear from you. So you have the floor.
I can thank you. That was not part of the deal about running the marathon. So let me thank you, because that means a lot to me. Thank you for for that intro. It's far more elaborate than I perhaps could possibly have done. And thank you for mentioning the marathon. Let me start by also thanking Mrs. Funia Kundayo, for the MD of STL, for giving me this opportunity and privilege to speak on a very sensitive topic, the role of a corporate trustee and the functions of the probate registry. As you all know, the topic relates to something that most of us would prefer not to speak about. In other words, something that is so certain and something that creates such dispute amongst families, something that destroys businesses. So I am not going to be approaching this solely from a commercial point of view. I'm going to be approaching it from a very sensitive perspective, in that I myself have suffered a bit from not being proactive. Now, when I finish my speak, there's going to be a questionnaire. And I'd like you to judge my performance by indicating whether you will take an action immediately I finish to do certain things. In other words, take one action regarding the administration of your estate. If you do not, then I have failed, because I'm going to be speaking to you, as I said, not only from my experience as a practitioner, but also I will share two quick stories with you before I delve into the main subject. And the first one is, I had a very good friend, and I'm sure a lot of people have experienced this before, is the son of a prominent personality in the country, so I would not mention his name. He passed on. He had assets in Nigeria, he had assets in Canada. But unfortunately, like all of us, there was no plan. On the next day after he passed on, beyond the businesses that since been liquidated, his family could not even afford the next meal. And this was a prominent gentleman. Now, what was interesting about it is not unusual, but I myself had no plan. And when I saw what had happened, I drove straight to the lawyer's office and I asked him to, that's my personal lawyer. I'm a lawyer structuring deals, but I didn't have any plan. And I asked my friend, a good lawyer who I trusted, to put something down for me. I haven't completed that exercise, but I will after this session. The second point is that we had a chief accountant here who's worked with us for close to 11 years. Last year, he passed on. Very unfortunate circumstance. He was being driven to his hometown on a holiday. He just took 1 week off and he had an accident and it was fatal and he passed on. Now, you can imagine how shattered we were. I remember him calling me from, immediately after the accident happened, before he passed on, saying he would be all right. He spoke to me. He spoke to my partner, Folabi Kuti, and we're all quite happy that nothing fatal had happened, but only for us to hear about an hour later that he did pass on. He had 3 lovely children, and he spent a lot of time talking about their education. He had a lovely wife who was a Catholic, but guess what? There was really no plan. But interestingly, we had set up a group life insurance by accident. We were applying for a particular permit. And of course, we meet our regulatory, we're compliant regulatory, but we were required to effect a group life insurance, which I'd almost forgotten about. Ironically, James, an accountant, would prefer that we didn't spend such money every year on the premium. But guess what? After he passed on, the deputy accountant came upstairs and said he's entitled to an insurance. It turns out he was entitled to 19 million. And then he's also entitled to maybe close to another 14, 15 million. Now, what did that do immediately? We set up an informal trust through our office. The children are guaranteed to go to university as a result. They're still quite young. The wife has a shelter over her head, which we're paying for. Now, that singular decision that day to effect a premium, that singular decision turned the whole life around of the dependents. That's what I want to achieve today. That's why I'm not going to be spending a lot of time on technical issues. I want it to be such that when you leave here, you take a decision. Now, there are 2 decisions you'll be taking. A decision to do something, and then deciding that you're going to use STL. STL will want me to say that. But that will come. It's like a doctor who says, I don't want people to be ill, but if you're ill, please come to me. So STL will be telling you, come to us so we can effect this. But I think STL is doing a wonderful thing to educate you on the need to take an action first. And then the secondary issue is to come to STL. Let me go straight to the paper. I am going to be brief, and I'm going to compartmentalize it in 3 parts. The first part, I will be dealing with a very basic question, which is a basic question of life. Why, when, whom? Why should I have the corporate trustees? Why should I have an administrator? Why should I effect a plan, an estate plan? When should I do so? To whom, for whose benefit? I'll be answering those questions. The next part, I will concentrate a bit more on corporate trustees. And finally, I will talk about what I consider to be recommendations, and I will conclude. I will try and keep to time. Most families lose wealth by the 2nd generation. Interestingly, that affects the social fabric of the country. So you don't have all the companies that have gone through 2, 3, 4 generations are all foreign companies. So the Guinnesses, Kellogg's, biscuits. If you go abroad, most companies were started in the 18th century and they go from one generation to another. Why not in Africa? Why not in Nigeria? 2 reasons, I would say. First of all, there's an absence of any effective trust to create this. Because what a trust does is that rather than pass your wealth or your business to the next generation, rather than pass it only to your first son or children who may not be sufficiently equipped to run the business, you pass it on to trustees who will run the business or appoint people to run the business and then pay your children who may not be sufficiently equipped to run that business. I will talk about my personal experience when I come to that subject. I'll go back to the first slide. It is important to recognize that immediately after COVID, the need for having some plan became even relevant. I personally lost a few people, not directly from COVID, but I suppose the illness they had was exacerbated by COVID. But what it also demonstrated was the certainty of death. Christians are not well equipped to accept the fact that there's death. Death is the most certain thing. The only thing we do not know is when. Now, if that is so certain, why don't we have plans? Moving the businesses, moving your personal assets from one generation to another. I will talk about it, and this is the most important reason why you need a corporate trustee. Who needs an estate plan? It's not only for the wealthy, it is also for the averagely wealthy or even for the poor. And let me give you an example of what I'm talking about. If you have nothing but just clothing, your immediate family might want to use those clothing. There's something sensitive about it when you pass on. And if they cannot use it, they usually will give it to charity. The question, who gives it to charity, is an asset. Who decides which charity you should go to is something that you can put down and pass on to your life. As simple as that. So everybody has an asset, everybody has an estate, which can be distributed as long as you are living and you're not walking on the street naked. We came into the world naked, we shall live naked. But once we come in, we are clothed. Those are assets that are capable of being distributed. Bear that in mind. Most people say, well, I'm not sufficiently wealthy. But if you sit down and you take your pen and you start writing what you have, just starting from the clothes you wear, you will see that you have an asset. It is necessary, beyond the fact of distributing what you have, to cater for your dependents. I think it is evil, unthoughtful to have young children without giving it a thought as to how they will live in case you are there no more. One simple way in which people do it is if you have an account, a bank account, you ensure that it is joint. There's a joint one with your wife. But many of the banks are beginning to give problems because, in my view, they don't understand how the principle works. When you're a joint account, when you're a joint mandate, you have a joint mandate with your wife, she's entitled to continue to draw on it. Now the bank said that if one partner leaves, you need to go and get letters of administration. That can be a problem. So make sure that you get clarity from the bank that they're doing what the law requires and they're not doing what they think is required. We've encountered many banks who refuse to allow a mandate. That is not the position of the law. But I think it's important to clarify that. Go to the next slide. Now, this is very interesting. If you have different assets, please think about it. We acted as lawyers, and I can say this very publicly because no matter went to court, we acted as lawyers on the part of estates of Tayo Adereoko. There are different assets, and there ought to have been different methods of distributing these assets. Unfortunately, just one method was used, and there were also many complications. Thank God we approached it from a settlement perspective, and that matter has been resolved. Next slide. When is the best time for estate planning? By yesterday. That's the best time. Now, if you look at the figures of those who passed on in COVID, in Nigeria, we suspect that the figures are not authentic, but even at that, there are 2,223 people who passed on. Now, many of those, I can tell you, did not have any plan. I had a few of my relatives who passed on. But for my father, who simply had a dying declaration, none had a plan. Please do not make that same error. Next slide. This is very interesting, and let me tell you this here. Why do people need a plan? So I'm going to compare three lawyers, prominent lawyers. Gani had a trust. Egobame, my father, had a dying declaration. Chief Williams' position is arguable. He really didn't have much. He had what we know as a holographic will. In other words, he had something penciled down in 1957, I think it was. Gani had a trust, and as a result, you still have the NWLR today, Nigerian Weekly Law Report. You have a publication. Gani was a publisher. He gave that publication to a trust. They appointed competent people to continue to manage it. When Gani passed on, his first son tried to unfold the trust, tried to attack the assets forming part of the trust. He was told straight away, even though he was a lawyer, that is not possible. So the trust continues. We still are privileged to continue to have NWLR. Egobame, my dad, did not have a will that was lodged, but he had a dying declaration. And this was necessary because my father I come from Benin. And in Benin, there is a way in which the main house is distributed to the first son, and the first son on record. My father told me a story. He said, once you come from anywhere in the country where there's primogeniture, in other words, property passes from father to first son, he's not seen anybody who's passed on, who's lived in a rented property, and the son comes up and says, you know what, my father has not paid rent, I'm the first son. He said, but once there's a property that can devolve to the first son, many people will come and say they are his children. So we had a dying declaration, say, I have only 3 sons. Anybody else who comes in will not be permitted to partake in that burial. And in Benin, if you don't partake in the burial, you're not entitled to be distributed. You're not entitled to the estates, let alone the main house where the deceased lived and died. So he used a simple method to deal with the problem. Chief William left it open. My dad's simple method, we still ended up in court, and the court accepted his dying declaration. So today I'm acting as an administrator. However, Chief Williams didn't do much. The most prominent lawyer, remarkable lawyer in Nigeria, today his assets are subject to litigation. They're in the Supreme Court. Loads and loads of assets now being depreciated. So you had 3 methods. One, a trust, another, a dying declaration, and the third, Chief Williams, and they found a will which they're contesting now. Which one is superior? Of course, the trust. So the question, why should I have a trust or a corporate trust, is answered by these 3 examples I've given to you. Go to the next one. What kind of assets are subject to trust? Any assets, and even new assets, cryptocurrencies, you can create a trust in respect of it. And the corporate trustees will advise you accordingly. Now, make sure you use a professional, and a good professional who is an expert in the area. We have come across different assets subject to litigation, subject to dispute, because non-experts have been used. It's not every lawyer who can assist you with the question of distribution. It's a very complex area. And so going to a corporate trustee is a good one. Calling a lawyer and be honest and say, is it just that you can draft wills? That's not what we're talking about. The distribution of your assets is subject to a particular type of procedure where you need an expert. So please use an expert. One other thing you could do is to use a protector, which is not very common here. What that simply means is after drafting your will, and this is very interesting, people draft wills. Wills are okay. But wills, by their very nature, subject itself to litigation, because for a will to be admitted to probate, it is exposed in the newspapers. Once it is exposed in the newspaper that these people have applied for probate, many more family members come and start contesting those the contents of that will. So I always say to people, if you can create a simple trust, it is superior to a will. And I talk about half secret trust. What do I mean by that? If you create a will, please create a protector. If you create, make sure there's a protector. If you create a trust, make sure there's a protector, a trusted family friend, where you simply insert there that if anyone disputes what is here, or if there's any ambiguity, please go to Mr. Osaro Egobame. Whatever he says should be final. There's also the question of half secret trust. Tell people that you domicile your wishes with STL, or you've domiciled your wishes with B or in courts, and let them know. They don't have to know the contents, and there will be less arguments about what you have done and how you choose your wishes to be effected. Of course, how you should be buried cannot be in your will. There's no point inserting that in a will and the will is admitted to probate 3 years later and then you'll be buried. Make sure you put that in a dying declaration and a letter. You keep it to a close friend, a doctor, a lawyer, or somebody. Okay. What challenges would you normally encounter? Make sure that you have all the information and make sure that the information you have is reviewed on a regular basis. But of course, make provisions for residuary. Again, experts will advise you. And if you come from any part of the country, there's always a tradition that is infused into estate planning. For example, no matter what you do in Benin, whether you do a will, whether you do a dying declaration, the house where the man lived and died must go to the first son, as long as it's biologically your first son. And even if the first son is recalcitrant, even if he's not entitled to it, you cannot disinherit him. There are ways in which you may be able to circumvent that through a trust, but putting in a will has been decided that this son is a useless son, he didn't take care of me, and therefore my property will not go to him. That portion that relates to where he lived and died will be set aside by the courts. Now, there are other methods for wealthy clients. I say you can simply domicile your trust outside the country because you have assets all over the world, and there are families in Nigeria who are beginning to do that. There are advantages because you have assets all over the world, and your interpretation of the trust will be in accordance with where the trust is domiciled. These are complex issues. You need experts to help you. For the average clients, and when I say average, I mean in terms of wealth, you can do a simple trust. Or you can actually put your assets in a company and decide that this is how it is. Please get advice. That's all I keep saying. Get advice from a lawyer, get advice from a corporate trustee. Record keeping is imperative. Wherever you keep your record, let somebody who's close to you know about it. Even the courts are not as secure as we know. We know that the courts got burnt, and you can just imagine the amount of records that we have lost. Go to the next one. This is what your experts will do. They help you identify your assets. You can do some of this. They evaluate some of the assets. They engage the services of special advisors. The tax expert is very good if your assets go beyond a certain level. Next slide. What is a trust? We use this word as if everyone understands it. It simply means taking your assets and legally transferring it to a third party to help you administer that asset for the benefit of third parties or for the benefit of yourself. It's a beautiful way to transfer your business from one to the other. What we find in Nigeria is that simply because you have a biological son who you've protected, you have refused to expose him to all the vagaries that you were exposed to, and you expect him to be as astute as you are mistaken. You sent him to England to school. You've taken a car to drive him from school, to drive him from home to school every day. When he has to take a bus, you go for night prayers that he can't take a bus. Meanwhile, you use the bus all your life. And you say, no, I want to give him time. No. When that happens, then you need a trust for those assets because those children cannot manage. Let me tell you my own situation. Go to the next slide. You can see two houses there. So this is my father's office on the left in Benin. He ran that office. It's his father's building. It's nostalgic. We didn't have a trust, but we operated like a trust because we're very knowledgeable. So my father died last year and we opened the next office. So we brought down the one on the left and we built the one on the left. That's what happens when you have a trust. Now go to the next slide. My mother is a caterer. So my other brother took on catering. Now you can see the left-hand side was a hotel, old hotel. On the day my father was intended, we opened a new hotel because we were brought up to think in a very dynamic way. Even though we didn't have a trust, we thought like trustees to expand the assets that our fathers had. That's what trustees do for you. Go to the next slide. When you create a trust, it's always good to create what we call a living trust. In other words, see how the trust works in your lifetime. And you don't have to be confronted with probate. You don't have to be confronted with wills. Mrs. Akoni will tell you about probate. It can be a very complex problem. And I don't want to diminish what happens with probate. But please, if you can avoid it, in all honesty, avoid it. And your corporate trustees can assist you to avoid it. Go to the next one. Why corporate trustees? I think I've dealt with that. It's imperative if you want a sustainable business, if you want to cater for your dependents, and because they know what to do. I have said there before that take a decision today when I finish. And if you want to go one step further, STL will be saying, please come to us. But they're doing something fantastic. They're adding value. Today, please do something. And if you choose, use STL. That's not the main purpose. The main purpose today is to add value. Go to the next slide. These are all reasons why you should have a corporate trustee. Go to the next slide. The roles of the corporate trustee, these are all the things that we do. And I think the best way to describe it is, you have Guinness that has been operating for many years. Why don't you have any business in Nigeria? The absence of an effective trust and the absence of an effective estate management is the reason why you don't have that, whether it's in the business or whether it's in your personal assets. They do all that, which I've demonstrated on the slides for you. You can see Gani was a masterstroke. I'm sure we're going to have the publications of the law reports for many, many years to come because he set up a trust. If he didn't, Mohammed is now dead. Clearly, Mohammed would not have been able to take it to the next level. Again, the probate registry, I compared corporate trustee to the probate registry, and it's almost like the difference between, they say Coca-Cola and, I don't know, Pepsi. They shouldn't let me say that, but you can see what happens. Mr. Connie will tell you the probate registry has gone faster. I think you can get your letter of administration in 3 months. But just think about it. You don't have access to income in 3 months if your spouse hasn't created alternatives. The corporate trustees will help you do that. Or just even a simple trustee. Go to the next slide. It's never too late to plan. I want to leave you with a small story, Meadow Hall. I say Meadow Hall because my kids went to Meadow Hall. When I went to Meadow Hall once, and my kids came back with what they call a party pack. And the party pack was almost a television. And I thought my kids must have stolen. I went back to the principal and I said, how did these kids get? Oh, they said it was a party pack and this parent brought the assets from London. I don't train my kids like that. Because if that child who gave out a party pack of that value has not started to work, what will he give out when he starts to work? I will end like this. In everything you do, for those of us who have children, please, for everything you do, in the end, you must have a program for your dependents. That's important. But what you leave in your dependents, in other words, the value is far more important than what you leave for your dependents. God bless you. Thank you very much.
Thank you, Mr. Osaro, for keeping to your time. You have saved us 1 minute. You delivered within 24 minutes. Thank you very much for that paper. Well prepared and brilliantly delivered. We appreciate the paper. Now, earlier we mentioned that we're going to take the poll all over again and see how many converts Mr. Osaro has now. We had 72 going for the corporate trustees earlier, and 20% for both, and 8% for private. So let's see if Mr. Osaro has been able to confuse us or convince us. So let's go ahead. So I have the results. And those who go for corporate trustees are now 78% from 72. And those who go for both corporate and individuals are now 21%. and the doubting Thomases are still 2%. So you still need more evangelism to convince the remaining 2%. Truth be told, because when we started, we didn't have this number. So it means from the 8% you had earlier, you probably have converted all of them. And the 2% we have now probably joined in the course of the presentation. So we appreciate your presentation, and that means you have actually delivered. So thank you very much, Mr. Osoro. We'll be going to the second paper. Like I said, the speaker for this is another practitioner. We are not doing theory today. It's practice all along. And the person taking it is Mrs. Taiwo Akoni, HOD Probate, Ikeja Registry. But before Mrs. Akoni will deliver our paper, let's quickly pose these 2 questions to you so that we test your experience with the probate, and we'll now see where Mrs. Akoni needs to address us squarely. The first one, we're going to take 2 this time around. The first one says, have you ever had an encounter with any probate registry in Nigeria? So that it will be from the point of experience. So do I have the result now? Still voting? Okay, have the results. This is a serious one. 50% have had experience with probate registry. 50% have not had any experience with the probate registry. So, and that is 90 people out of the 137 people that we have in the audience. So, Mrs. Akoni, it's good that you have 50% of the audience that have had experience with the probate registry. Let me quickly pose the second question. And it says, how long did it take to process probate letters and or letters of administration, as the case may be? For those who have had experience with the probate registry, how long did it take you to process your LAs or probate letters? Now the result is A. We have 61 people that answered the question. 48 people said that it took them over 1 year to process their letters of administration. That's 48%. 38% said it took them over 6 months. And 50% says it took them 3 months. 2 things may account for this. One is that we want to believe not all of them process their probate in Lagos. So it's possible that the people that spend 3 months actually processed outside Lagos. Or they want to say, okay, things have improved and we cannot get our probate out in 3 months in Lagos State. These people have actually laundered your image for you, Mrs. Akoni. So that means it's possible to process probate in 3 months. But we'll leave that to you to present your papers and take us through the whole gamut of processing probates in Lagos. Before then, I'll quickly read the profile of Mrs. Akoni. Mrs. Akoni was appointed as a magistrate in year 2001. She is experienced in family and probate matters. Ms. Akoni is a Chief Magistrate Grade 1 with Lagos State Judiciary. She obtained the Bachelor of Law degree from the University of Ibadan in 1988. She thereafter enrolled at the Nigerian Law School and was called to the Nigerian Bar in December 1989. She obtained a master's degree from the University of Lagos in 2012. She was in private legal practice for many years in the law firm of Afolabi Adenira & Co. and Ayinde Sani & Co. before joining the Lagos State Judiciary as a magistrate. She has risen through the ranks and now a chief magistrate. She has also attended several workshops, seminars, and trainings in the areas of family law, judicial ethics, computer training, acquisition, etc., etc. Her worship is currently the HOD, Probate Ikeja Registry. She will take us through the entire value chain of obtaining probates from application to issuance. Your worship, we're happy to have you. Please, you have the floor for the next 25 minutes, ma'am. Mrs. Akoni.
Good afternoon, ladies and gentlemen. I'm glad to be on this platform, and I appreciate STL Trustees for the invitation. I look forward to a robust and interactive discussion of experiences, suggestions, recommendations, and possible solutions from participants as regards this presentation. I'm to make presentation on the procedure of obtaining probate and the challenges and the panacea that accrue to the obtaining of same. I would say that when I was first approached to make this presentation, I developed a kind of fear because I knew that I was coming to make presentation to people that are vast in this area of probate matters, intellectuals, doyens, and doyens in the profession. So I thank you once again. Before I go on with my paper, I want to say and agree with the learned Sikh on some of the submission he had made as to the advantage of having corporate trustees and making a proper planning. Why did I say this? I've had people coming to my office, sometimes lawyers, and their complaint is that this family, the way they are seeing these children, they will deplete the estate before, by the time they have access to this estate, and the testator does not want this to happen. I always advise them. I said, go to a corporate trustee to do the work for you. But each time I do, they always come up with the excuse that they can't afford the expenses. But I just wonder, why do you bother about the expenses? I mean, you are not going to be there to see how much is going to you are going to pay for these services after you have gone. You want to keep this estate in your name. Why can't you protect it? Why are you running away from it? That is, by the way, that is not my topic. I go straight to my topic. It is a known fact of life that at a point in time in life, in the voyage of our sojourning on this earth, we get to our bus stop and then we come down. And therefore, where proper planning has not been made, like suggested by the learned sick, by maybe creating a trust, the probate registry is there. And that's what we do here. What we do in probate registry, especially in Lagos State, is that we are under the High Court, family division of the High Court, and we deal with non-contentious matters of non-contentious probate business. The contentious business are taken before the court, but the non-contentious ones come to us. And there will be a non-contentious probate business where there is no dispute as to the validity of a will, if a will is left by the deceased person, or maybe there is no will left at all. The person died and then there was no will, there is no any preparation at all. They can come to the registry and then we do the proper thing. Where there is a will left, probate will be, they can apply for probate in order for them to be able to access the assets that the deceased had left. The deceased may have left assets like money in bank or in other financial institutions, properties, real properties, shares in companies, money in financial benefits by way of pensions and gratuity. For the loved ones to be able to access all these things, there is no financial institution that will release the money without them going through the proper channel, which is the probate registry, to get a grant. So where there is no valid will, or there is no executor to act, then probate will be given the grant of probate. Where there is no will, letters of administration will be given to the applicants or the loved ones that survive the deceased person. And that is what the business of the probate registry does. And it comes under the overview of High Court's probate services. So please, to the next slide. Before now, that is before March 28th of 2019, the probate business in Lagos State were done manually. This kind of creates some issues and challenges. Sometimes it takes like 4 years or more for a grant to come out. Sometimes the staff creates a kind of scarcity of probate forms, and the applicants cannot have access to the forms on time. This kind of delay the process. There are also improper record keeping. And then, of course, it affects the generation of revenue. It's either is low or there's no revenue at all. And government was losing a lot of money due to corruption. The probate business was also obscure. I mean, it's uncertain. People cannot just say this is what they do there and all that. I mean, it's kind of creates this discouragement in applicants. In fact, I discovered that when I resumed here, many files were abandoned because you look at it that some of the monies they want to access are just too small, but the trouble and the pains that they have gone through, they can't just continue, they will abandon it. So it was really a nightmare. I mean, getting a grant. Not only that, even after getting the grants, to check records, previous record was a problem. People were not willing to lodge their wills with the registry because when they needed them, for them to get it, it's always a problem. So the authorities sat down and looked at it, what can we do? Then they came up with e-probate, which was launched by the previous, former Chief Judge of Lagos State, Justice Opayemi. Okay. So when e-probate was introduced, we were able to solve some of the problems that show forth in the manual operation of the probate registry. And some of the things that we have, some of the advantages that we have, were that we're able to eradicate missing files. We're able to eradicate the slowness in the process. So now the introduction of the e-probate came. And when the introduction of the e-probate came, the manual processing, we were able to eliminate the manual processes of filing. So forms were made available online for applicants to download. They can fill in all their information and then download same and bring it to the registry. But in case they cannot do that, we also have a resource center where we can assist them to do this. And that very day, they collect all the forms and the bank certificate for them to be able to take it to the proper financial institutions where the disease has assets. There are advantages that are also accruable to this process of e-probate. Part of it was that we developed an electronic structure in addition to aiding a faster system, and we were able to get rid of bureaucratic challenges in that it leads to a reduction in time of the grant coming out, and then it also reduce the corruption tendency of the staff. We also created an information system such a way that applicants can chat with a staff. We have emails that they can make complaints to. Each of the staff has an email. We also have phone lines that they can call when there's any issues that they are facing or there are challenges. So these are the advantages that came with the e-probate. We were also able to disseminate information and receive comments and then feedback. I remember the first time we started, there was applicants in England, and we were back and forth, we were exchanging mails, and he was really encouraged. But I will not say more than that now concerning that. So I go to the next slide. If you look at the next slide, we see the way we were looking at the e-probate to operate. We have the digitalization, and then the archive system, which we are also trying to do the digitalization now. We are on it. We are still working on it. And then the advantage that comes with it is an intensive capacity building. The next slide, please. The advert of the e-probate was done in order to increase the efficiency in our service delivery, and then bring a reduction in the time from the process to the issuance of the grants. And when we started in March 28, 2013, I can attest to the fact that there was an application that we did within 3 months, and the LA came out. But these are they are subjected to the cooperation of the applicants themselves, because they need to be available each time we need them. Like the payment of estate fees, if you ask them to go and pay, some may just go for days and then you not see them. But if the applicants are ready to cooperate, they make the payment immediately they are supposed to pay. We call them for their shorties. They are ready to produce the shorties. We call them to come and do this. They are ready to do it. Honestly, the process can come out within 3 months, especially if there are no property, if there are no real properties in the application. But where there are real properties, there may be a kind of delay because of the process that is going to take through. Because if you go through the probate, it will go through the valuation unit. From the valuation unit, it will go through the probate judge, and then to the chief judge for an approval of the valuation. So this may kind of slow the process, and then we are looking at like 6 months or thereabout. Probate application can now be submitted through Lagos State Judiciary Portal. It's seen on the slide. at the probate.lagosstatejudiciary.gov.ng. And this application can be done even in your sitting room there. It can be done in your office by you visiting the website. And when you visit the website, you sign in using your email as your username. When you use your username, you create a password for yourself. When you create a password for yourself, it asks you two questions. Is it individual or organization? So you can open an organization, and then that organization page, you can always use it for other applications that you may be having. After doing that, you confirm your application through your email. After doing that, you log in and choose your preferred application, maybe from the different modules available. It could be for Lagos or for Ikeja division. After you have made your submission, you must make your submission within 30 days, because if you don't make it within 30 days, you'll be pushed out from the system, and then you have to start all over again. Next slide, please. The level of the digitalization that we are looking at, first, is to automate probate registry business process right from filing to final disposition. That is our target. We are still on course. We are still on course. We are still doing it, and I know that we will get there. Then from there, to automate the way files are processed and stored in the most secured manner in the probate archives. We are at that level now. We've purchased computers, and we are looking at putting in the information into to store all our files, especially the finished files, into our archives. So we will not be doing it manually. We'll be doing it digitally. We are also looking at to automate probate archive, reducing the case. Can't see this one. Oh, it's gone. The next slide, please. Oh, okay. I will go to the next slide. That is that who can apply? Who can apply for letters of administration? The hierarchy had been stated in my paper of the person that can apply. That is the surviving spouse of the deceased person, the children of the deceased, parents of the deceased, brothers and sisters, etc., and the creditor. The next slide, please. This slide I have now. Can't see this heading. I can't see the heading. Hold on. I can't see the heading. What is this word? No. Okay. I'm sorry, I couldn't see the heading of the other slide, so it has to be removed. But this other slide I'm looking at is the process and the stages that an application will take effect from. That is for letters of administration and for probate. The first one I'm going to look at is the letters of administration. When an applicant comes into the registry, it will start from the inquiry table. There he will submit his application and his letter of and the copy of the death certificate, the affidavit of not having applied before, valid ID cards of not less than 2 administrators and not more than 4 administrators as provided by the law. After the submission of the application, we go to previous record to check whether there had been a previous application in respect of that estate or not. If it is found that there had not been any application in respect of that estate, it is pushed to the next table, which is the next probate officer, who we now assess and send to the cashier unit, so that they can make payments for the letters of administration forms and obtain their receipt. Like I said earlier on, I said we have a resource center where we assist parties that cannot and that are not computer savvy, and they will need our assistance. So in that case, when they come, they first go to the resource center. They give them their information. When they give them their information, they direct them to the proper table where they can make payments for the services that we will render, which is about 3,500 naira. And then they come back, they go back to the inquiry. The inquiry decks will check whether there has been any previous application in respect of that estate. If it is found that there is no previous application in respect of that estate, the file will be, the applicant will be directed back to the resource center so that all their information can be filled online. And then they will download all the information already contained in the field form, and then give them the bank certificate so that they can take to the necessary financial institutions where the disease has assets. After that table, if there are no property, assessment will be, the applicant is required to take the bank certificate to where the disease has assets, get all the assets endorsed on the bank certificate, and then bring them back, and then we now assess for estate fees to be paid. After the estate fees have been assessed, they are made to go and make their payments by bank draft to the designated bank, and then they also make payment for publication. After making payment for publication, they are required to produce their shorty. We push them to the shorty unit where they are required to bring their shorty for interview. After the shorties have been produced, the file will go for publication, and the publication will take within 21 days, within 21 working days to expire. If there are no any caveat filed, the file will move to the pool, to the typing pool unit, where we type the white copies. When we type the white, no, we type the minutes and order. When the minutes and order are typed from the typing pool, it moves, the minutes and order are passed to the probate judge for signature, where they will check whether the proper payments have been made, whether the necessary affidavit have been sworn to, the requirement for shorties have been complied with, and if there are any other issues that are found not to have been complied with, the file can be returned back to the probate registry for the necessary things to be done. Where there are no issues, the file are returned back to the registry, and then it goes for the grant to be drafted. We draft the grant is prepared. The grant is now returned back to the probate, to the head of the probate, who checked to see that every other things are all right. If there are also any other issues seen in that early, the head of probate can also query it for the proper things to be done. If the proper things are done, it comes back to the probate, to the head of the probate again, to ensure that the proper thing has been done before the file are returned back to the probate registrar for signature. And after the signature of the probate registrar, the letters of administration is ready for collection. But for probate, please the next slide. For probate, that is where there is a valid will left. At first, they go to the inquiry, submit the application for the search of the will. After the will had been found, they will bring an application for reading of the will. If the will had not been found, that is another issue entirely. But where the will had been found, payments are made for forms, and receipts are also issued. These are also done online. We do the filling of the forms online. We check the record section too to see that no application had been taken in respect of that probate. From there, it moves to the assessment. It moves so they take the form. Oh God of mercy, it has disappeared. Is there a way that we can remove this, please? Okay. So where payments have been made. No. It's gone back to letters of administration. Sorry. Okay. So where payments have been made for probate forms and receipts issued, we will still require them to take the bank certificate to where the deceased had assets, like monetary, like if they are money in financial institution, so that the bank certificate will be endorsed. And then they bring it back to the registry for assessment. Where there are properties, the file will be pushed to valuation unit so that the property can be valued. And then from the valuation unit, it goes to the probate judge for approval of the valuation that has been done. From the probate judge, it goes to the to the chief judge for approval of the valuation that has been done, that has been approved by the probate judge. From the chief judge, the file will be returned back to the registry, where the proper assessment will be done again. And then we ask them to go and make payment for the estate fees in bank draft. And there is no publication when it is probate. There are no publication because it is taken that the testator had appointed who effect can represent him properly. So there's no need for any publication when it is a probate. There's also there will be a need to mark the will by the executors and the executrix who are witnesses for their, so that we can look at their signature on the original will. After the marking of the will, the minutes are drafted, and then it goes to the probate judge for them to go through all the necessary, to make sure that the necessary payments have been made for the estate fees. If there's any need for an affidavit to be sworn to, that those things have been complied with. And then the minute another comes out from the probate judge, and then we draft the grant. After the drafting of the grants, the grant comes back to the head of the probate for us to see whether there is any mistakes, it is properly drafted. And after we ensure that it has been properly drafted, it goes back to the probate registrar for signature. When it gets to the office of the probate registrar, they still go through the grants and the file to see that the proper thing have been done and the proper payments have been made. So after the probate registrar had signed, the grant is ready for collection. Yes. I talked about what is a previous record. Probate records are court records created after an individual's death, that a court decision regarding the distribution of the estates to the heirs or creditors and the care of dependents. This process took place whether there was a will or not intestate. The previous record are needed to ensure that there are no duplication in respect of an estate. Because what we discover before the advert of the e-probate was that there could be series of applications in respect of one estate. In fact, there was a particular estate that we saw 3 files. And some of the administrators had even different. This is what e-probate had been able to eliminate, because it will show on the system that there had been a previous application in respect of that estate. So that is what previous record does. It's filter to see whether there had been a previous application in respect of that estate or not, so as to avoid duplication of probate or letters of administration in respect of one estate. The next one. I also talk about archive management software. I said earlier on that we are at that stage where we are working on digitalization of our archive. Although we have a mini one that we are using presently for working files. But for the old files, we are just trying to ensure that all our old files are also input into the system so that we can have access to them easily when they come for amendment of grants, when they come for additional assets, when they come for like they are appointing new administrators or executors, we can be able to access the files easily so that they can be able to carry out what they want to do in respect of that file. This is used to manage storage and retrieval of probate record. Each probate record has a unique barcode, and each archival bus has a unique barcode. Records are kept by bus level, row level, column level, rank level, location level. So when we are looking for a file, by the time we punch our computer, it will tell us where the file is by bus level. It will tell us where the file is by row level, by column level, by rank level, and by location level. Confirmation process. We also have the confirmation process. Usually when grants have been obtained, the applicant goes to the different institutions to be able to access the asset that grant had been granted upon. Some of these financial institutions will not just release the money, they want to confirm whether those grants really emanate from the registry or not. So when they come, confirmation had to be done. So the confirmation process, we are looking at it being done digitally. We are still in the process, but because of the fees that are involved and charges that are involved, we are still discussing with the banks that are involved. The online confirmation of grants, we first purchase a ticket online. You look up for the record, and then you print authenticity receipt. I talked about what is estate fee. Estate fee is just like a tax, and it is usually 10% of the value of the estate that is being paid to the government, where letters of administration are involved or properties are involved, although that of the properties differs. But I will just leave that alone now. Why is personal charter very important? Personal charters are important in order for us to be able to for tax purpose, because it is the 5% of what the charter is that we use in working out the assessment for, especially where it involves where the money to be assessed is pension. So to the next level, please. We also talked about, I've talked about this. We also talked about newspaper publication. Newspaper publication are made in Gazette or newspaper. This is done in order to ensure that if there's any objection to the people applying, especially in letters of administration, to the people applying, that maybe they are not, whether they are not the proper people to be the administrator or not. So it will give them, like, it's like a notice to the world. If you have an objection to the applicants, you can always bring your application. You can always file your caveat before the probate registry. I've done that. So, we also have a big or small. We also have a small estates, but because of the time, I will just refer us to look at the paper because I've exceeded my time. So I will refer us to look at the paper, and we want a suggestion. We are not. We are available for suggestion, for recommendations, in order for us to move forward, so that we can still provide better services than we are doing now. Thank you very much.
Thank you, Mrs. Akoni, for that well presented papers. It was actually educative and insightful, especially to practitioners that wanted to know how things work at the probate registries. So we appreciate your presentation, madam. Now quickly we'll go, we have overshot time for presentation, so we have about 10 minutes to go, but within that 10 minutes, I think we can take a couple of questions. Some questions are here in the Q&A box, and I can see that Mr. Ebubame has answered some of these questions. We'll probably go through it for the benefit of some of our audience. Someone wanted to know, in case of conflicts between a trust and the custom, which takes priority. So Mr. Ebuwamenesen has answered that question, that the trust will prevail. But when it has to do with custom and legality, legality prevails. And if it has to do with a will, then the asset under the will being subjected to the custom may have its way, but there's a way that you can couch it in your will so that it doesn't cause issues after you've gone. Also, there are questions on issuing the certificate to participant that has been answered. We don't. How does one establish a trust? You can get in touch with STL Trustees. You can leave your details also, so we get in touch with you. Someone wanted to know the difference between testamentary trust and living trust, and the answer has been provided. Living trust is the one that operates while you are alive. The testamentary one is the ambulatory one that takes effect after death, and that means that the trust is actually created under will, and the asset under it will pass through the will, and if it's contested, it's after that has been sorted out that the asset passes into the trust. For other ones that are yet to be asked, let me quickly see how many of it that we can ask within our time. And let me assure us that any question that we are not able to ask on this platform, we will take it and answer and send, and link up with our website so you can access the answers to such questions on our website. But before then, this question, maybe I will want to answer it. It says, that's from Titi Adegbile. It says, at what point do you pay corporate trustees to be executors? And what does it take in regular terms to have STL do a personal trust? Your corporate trustees, when you appointed a corporate trustees as executors, their work does not start until the testator has passed on. So in which case, it will not be necessary to pay except for the take-home fee that will validate the appointment of such executor. But after that take-home fee, nothing is payable again until after the testator has passed on. Then on a pecuniary terms, to have STL draw up a personal trust, you can get across to us on that. We'll explain everything to you, but one thing we can assure you of is that fee is never a deal breaker at STL Trustees. The next one says, so it's actually an observation. The person does emit to no carry. It says the probate is tedious even after one has taken time to write a will. Let me quickly point out from the presentation of our worship. She mentioned that if there are no real assets involved, then it could be expedited. Within 3 months, you can get it out because you won't have to go to valuation point when they have to value and now tell you. It's just basically on what you have from your bankers and all stocks and all sorts, and the percentage is assessed and you pay via draft and you come back within 3 months. That could be done. But when it entails real assets, you probably have to be more patient. Can one commence probate if there is no will? Quickly, maybe I should mention that for when you have a will, you process probate. But when there's no will, what you process is letters of administration. And that, can be done the moment the person passes on. You have your death certificate and you apply for your for the letters of administration and follow the process. I don't know if Mrs. Akone has something to add to that.
Mr. Oni, you have answered the question. There's no way they can get a probate without a will.
Oh, okay.
Yes.
The next question that you may need to answer, madam, is that in case of letters of administration, what percentage does the government take?
It's 10% of the value of the estate.
Okay, thank you, Emete. You have your answer.
But where it is pension and gratuity, there's no payment. What we do is to give a value for the personal charters.
Okay.
And
Great.
then we charge it at 5%.
Great, madam. Thanks very much. For practitioners, pensions and gratuities are not taxable. Ekene, how do you communicate assessment to clients without having to come periodically to the probate office to check for feedback? That's for you, madam.
I think sometimes I do call the applicants. I do call them, or I instruct the staff to call them that they should inform the applicant that assessment is ready.
Oh, great.
So I will look into that. Yes, I will look into that if they are complying.
Thanks, madam. He also suggested that you can make use of email or SMS or WhatsApp to communicate to clients at that stage.
We look at that. Email. An SMS.
Please elaborate more on access to pension during will administration. That has been answered. Please, you would recording of this webinar be shared with attendees. Yes, we'll link it with our website and you can access it from our website. Where two different letters of administration are given to two different parties for the same disease, what happens, madam?
One has to be set aside, and yes, and is the latter will be set aside.
What if the former was obtained fraudulently?
It is the court that can set aside. We cannot set aside. It cannot be done administratively. Okay. So they have to go to court to sort it out.
Okay, Elizabeth,
yes.
Okay. Mr. Ebobame has answered the question from Sopruchi Rufus. Chayo Adenka, please, how can you set up a trust? Can you advise me through the creation of a trust? Like we mentioned, please let's have your detail. We'll get back to you on that. That we seem to have exhausted the questions, and if there is any, so I mean, we have 2 minutes to go, but I have 1 or 2 questions for the learned SAN. In your presentation, you mentioned that a client may make use of private banking or trust. What priority or benefit does trust have over private banking, Mr. Ibugwami?
Well, the private bankers that I know, first of all, they not, because they're bankers and they can help you. Barclays Bank had a trust at that time. They had a specific trust department. In Nigeria, the bankers are assisting you unlike where a trustee is specifically given that function and is regulated. What a trustee does, because they are regulated, there are certain things they cannot do. The banker is not specifically for that purpose. So it's almost like using somebody who has some knowledge, but somebody who is specifically created for that purpose to hold property on behalf of a third party. And then you have all the sort of things. When the bank folds up, for example, those assets, I don't even know if they'll be treated like trust assets because they're just part of the bank's assets. Whereas a trustee, it is clear that the assets that they are holding is not their assets, and therefore it is taken away from insolvency. I think that's the greatest advantage. So you're going to, it's like going to a specialist as opposed to a general practitioner.
Okay, Thank you very much, Mr. Ebubamen. I probably want to add that when you move your assets to a trustee, that asset does not fall within your estate again, as long as the title has been passed to the trustee. So when you are processing your probate or letters of administration, it's not actually part of your asset, so you're not going to pay any tax on such asset that has been moved. But if you have your assets with a private banker, it has to go through probate before it could be distributed to your beneficiaries.
Okay,
the next
just to correct, not to correct, just to underscore what you're saying. If the bank has a specific trust department, many foreign banks have that, you can actually transfer the asset to that specific trust. So it's almost like the bank is superintending over a trust. But if you create a testamentary trust, and this is where the distinction is important. In other words, you create a trust in a will, it still has to go through all the probate and you have to pay. So this is where you need proper advice to create a living trust as opposed to a testamentary trust. Very important.
Thank you very much, sir. Also, to further clarify that if any bank in Nigeria has a trust arm, it has to be licensed by the SEC, the Securities and Exchange Commission. As long as that arm of the business is not licensed, the bank does not have right to hold that. That I'm talking about Nigeria. So the bank does not have the right to, hold such asset without it.
You are very correct. Very correct.
Yes. My next question, sir, is: would you like to quickly elaborate? To our audience, please. This is 12:33, and we promised 12:30. But for also your benefit for attending this, we'll probably want to clarify one or two things. Which one do you think is cheaper? That's the cost effectiveness of setting up a trust over probate. Our audience may like to know that, Mr. Ebubamen.
Well, you're comparing two very different things. It is abstractly expensive with probate, and let me explain what I mean. Although it is cheaper to just write a will and submit it, as Ms. Akoni has demonstrated to you, first of all, 3 months is a golden rule. Then secondly, probate must be public. Even though the wills are not advertised, you must read it in a room. In that room, the day they invite family members, just go there and see what happens. The dispute starts from that room when that will is read. And once the dispute starts, it becomes very expensive to solve it. Mr. Kondi will tell you, just go to the probate room. You don't even need to go. You feel the tension from when they're reading it. People who had expected things to be given to them and they're not, they will be spoilers. Even I'm almost getting to the point where I don't want to act as a trustee for any family member because it's just too messy, because expectations are dashed. So in that sense, it is extremely expensive because those who are even legitimately entitled, because the dispute has started, may not get it for a long time. So although you pay money to the corporate trustee who avoids it, especially if you create a living trust, so it looks on the face of it more expensive. It is a kind cruelness to your dependents to leave them to the vagaries of the probate office and the family members. So I think in all, I would say personally that it's far, far cheaper, even though you are putting your hand in your pockets and paying something to the public trust, to the corporate trustee or to a private trust or a law firm or whatever. So in my view, from my experience, it's far, far, far cheaper to work with a trustee. Of course, I understand depending on the type of assets. And if you have a very small asset, you can do a small structure with your bank, make sure that your banks are aware. There's certain small things you can do. Please just avoid probate. Open up to your wife because she will suffer when they are reading that thing in there, please.
Thank you very much, Mr. Ebubamen. And it's also vice versa. Some women have assets more than the husband. So
that's a very good one. And the ladies are doing very well today. So in fact, a lot of them have more than the husband.
So my last question goes to Mrs. Akoni. what are you doing to reduce the time wasted in the process of probate? You've explained to us that when real assets are involved, it goes to the valuation department where it may take some time. I also understand that at times they will say, oh, we can't go to that area now, and there's something around that. So the process of valuation is actually takes a longer time. So what are you doing to shorten the time involved in processing valuation? Probably I want to suggest, is it possible for you to have something like the timelines within which an officer must treat a file if it is not queried? Thank you. You are muted, man.
Okay. For valuation, it is not all properties that are visited. If it's a property that is in a prototype and then land that are not developed, they don't go to the land before they come out with their valuation. And some properties are not even visited. Once the Google map can pick the property, yes, they don't visit the property. But where it is a developed property, sure, they must be there because they must know the kind of structures that are put on the land. As to that of the registry, we are trying all our possible best. But what I discovered recently is that with the NSAS issue, most of the work are now on Ikeja. Because Lagos State is Lagos Division are still not finding it easy after the destruction of all their all the things that they were working with. They destroy everything. So the numbers of applications are increasing every day. In fact, as of the time we came back from this strike, we've had 3,000 files in Ikeja alone, open. 3,000 files. So we are trying our best. And you see, the staff are working under pressure. In fact, what I discovered is that some of them will say they are sick. I said, if you are sick, stay off work, because that's the policy now. Because you don't know the nature of the sickness with the COVID that is everywhere now. But we are trying all our possible ways to see that the time lag is reduced. But sometimes you see the delay comes from the applicant themselves. In the sense that when we call them, this is the stage where you are, this is the stage your application is. You are supposed to pay estate fees. Some of them may go for months before they make payment for estate fees. And where these payments are not made, you cannot go to the next level. Where shorties are supposed to be produced, they are not produced. You cannot go to the next level. So we need the cooperation of the applicants too, for us to have a shortened procedure.
Thank you very much, madam. We really appreciate your time. And also to Mr. Ekobamen, we thank you for these well-delivered papers, and our audience are very grateful for the well-thought presentations. Fadila attested to the destruction by SARS unrest. I mean, Akin Jisola Ayomide attested to that. Fadila will get a response from the link to our website that we'll send after this webinar. In all, we want to say thank you to our speakers. We appreciate the practical angle from which we have taken your slides and thorough explanations on say. And to our audience, we also appreciate you. You stayed true even when we exceeded our time by 10 minutes. It's not in our character to exceed our time, but we appreciate you. Now I'll call the MD CEO, Mrs. Kondayo, for our close remarks as we bring the webinar to a close.
Just before you go, I just want to add that if there are any questions, they can direct it to you and direct it to us. We'll be very happy to have a follow-up. And I continue to run for justice. I invite many people to join me. But took no notice. Thank you very much.
Okay. Thank you very much.
Thank you so very much. That has been quite engaging, quite insightful, and quite enlightening. I think Mr. Akini has done the bulk of my work for me, because in my closing remarks, all I need to just say is thank you to everyone. Starting with our speakers, the Senior Advocate of Nigeria, Mr. Saro Egobeme. We are extremely grateful that you have made yourself available to do justice to the paper at today's webinar. Mrs. Taiwo Akoni, we thank you very much, Madam, for your time and for a job excellently done. We thank you both for your brilliantly delivered presentations. I want to believe that the two presentations have stimulated some kind of desire in the mind of our audience today to do the needful as far as estate planning and wealth transfer is concerned. We thank you very much for sharing your wealth of knowledge and wealth of experience with us on the subject matter of today's webinar. Thank you so very much. To our wonderful participants, we cannot thank you enough. We had almost 100% attendance at the beginning. Even as we're about to close now, we're having something close to that number. That shows that you were truly engaged, you paid rapt attention, and then you followed through with us with the presentations. We thank you for your time. We thank you for taking time out of your busy schedules to join us today. And we also thank you particularly for your very engaging questions and comments. For the questions that we have not been able to answer as a result of time constraints, be sure that we'll answer those questions. And in posting the slides to you by email, we're going to be attaching answers to the questions that we have not been able to take at this time. Thank you very much. To our very able moderator, Mr. Akioni, thank you so much for your efficient coordination of the entire webinar session. At STL Trustees, we're always available to offer you the best-in-class trust services, and we look forward to hearing from you after this time out. And most importantly, we look forward to seeing you again in our future webinars. Thank you so very much. Enjoy the rest of your day, and goodbye and God bless. Thank you.
Thank you. See you at our next webinar.